In December 2023, the four justices of the International War Crimes Division Court, sitting in Gulu, found the former Road Resistance Army Commander Thomas Kwoyelo with a case to answer on 78 counts out of the 93 counts, which were leveled against him. The offenses included crime against humanity, war crimes, murder, violence to life, outrage against personality dignity, and cruel treatment, among others.
A case to answer means that the evidence which has been given, if you don't give an explanation, you may be convicted. But if you give an explanation, now there are people we know in our legal circles who were charged, they decided to keep quiet, they were acquitted. For instance, you remember the sheikhs who were charged. They kept quiet, they were convicted by the ICD, but Court of Appeal set aside the decision. You also remember Besige's rape case. So there are so many cases.
Kept quiet.
You can decide to keep quiet.
And he was
but you also remember that in the case of Sezi Cheye, he decided to keep quiet, and the court up to Supreme Court did not know his side of the story. So for us, we find it important that the court should know your side of the story. That's why for us, but by saying that there's a case to answer does not mean that you are guilty. It is just an invitation that, hey, they have talked about you here. Can you explain? If you do not explain satisfactorily, that side remains. But still, that does not stop the prosecution from proving their case beyond reasonable doubt.
Friday, Thomas Kwoyelo met with his legal team at the International War Crimes Division Court offices in Kampala, led by Caleb Alaka, together with other lawyers to plan his defense.
We are interviewing our client, Thomas Kwoyelo, and in the interview, we are guiding him on what kind of defense he's going to give. After this interview, and after getting his witness details, we're also going to go to Gulu next week from 18th until 27th, where we are going to do defense outreach. On 19th, we shall give a status report. It's usually done within the stakeholders on our activities. The reason why we are doing all these things is we want to get prepared, and we want to give a very robust defense for Kwoyelo. Because definitely, as far as we are concerned, in as much as there was a case to answer against him in those 78 charges, we have explanations. He has explanations to those counts.
During the interview, the defense legal team disclosed that over 50 witnesses will testify during Thomas Kwoyelo's defense.
Yes, we discussed the options, and we have left it to him to decide. Because ordinarily, but what we are going to do is we are going to avail witnesses. Preliminary, we have around 50 or 60 witnesses whom we shall call. He is going to give a defense. He's not going to keep quiet. That one we have agreed about it. We do not know on that. That one we shall have it.
He will decide himself
at the last minute. Yes. So that's that. Today, the whole day is ours. Yes, today the whole day is ours. If it's not enough, we shall reapply to have him. But from next week, when Igulu preparing for in the gutters, going down in the villages to get our witnesses and prepare them and be ready for the trial.
How many did you say?
Around 50 or 60.
The team, however, applauded the Judiciary for providing a conducive environment since commencement of that trial.
But more importantly, we really want to thank the leadership of the Judiciary. We want also to thank the head of this division, the judges, the permanent secretary of the Judiciary, and the deputy registrar of this ICD for facilitating us to make our defense possible. In most cases, you'll find accused people are not given equal treatment with the prosecution. But this time, at least we are very glad that the Judiciary, the government, most importantly, the permanent secretary, the deputy registrar, the head of this division, and the head of the Judiciary, the Chief Justice and the Principal Judge, have assisted us, given us facilities in terms of funds for us to prepare ourselves to get witnesses from Amuru, Pabo, Parabang, all those places. And also to allow us to go and tell people the story in terms of outreach, explain this ruling so that people understand that Kwoyelo is not actually convicted, but he's going to give his defense.
Councillor Alaka added that preparations will be concluded by 15th February 2024.
And whatever will happen will be afterwards. We want actually by 4th of February to be ready for our defense. It will now be up to court from 5th. For us, we shall be ready by 5th of February. If court will not be ready, because you see, this trial has been extremely long. Kwoyelo has been in jail for over 15 years. So we want an end. We want a court to pronounce itself. So with this good and able facilitation we have got and the leadership we've been given, by 5th February we shall be ready in Igulu for our defense. And I think before even in 3 weeks or 6 weeks, whatever it takes, we'll have finished. And we expect, if things go by this, by April there must be a judgment in this matter, so that this matter is closed. We want a speedy, we're the ones who have been advocating for a speedy trial, as enshrined in Article 28 of the Constitution. We want to demonstrate,
the one which delayed everything.
We want to demonstrate that it can be achieved. So we thank you, our friends, the media. Thank you. You see, there must be a fair hearing in any trial. And for there to be a fair trial, both sides should be heard. Court, in giving its decision, must take into consideration prosecution side of the story and Kwoyelo's side of the story. For instance, how will the court know that Kwoyelo was abducted when he was 12 years old? How will the court know that Kwoyelo was not given protection like all those other kids who were abducted by government? How will the court know all these things? Even if court is to find him guilty, how will the court have mitigating factors if we do not prepare? So this exercise is very, very important. Without it, court will not know his side of the story. Without it, court will not know that he was a victim like all other victims. Without it, court will not know whether some of the testimonies were lies or not. So it's very, very important, not only for fair hearing, but also for court to know his side of the story. Because in making his final decision, court will weigh what the prosecution said and what he said. Now is in the setting. Ongwen was charged by the ICC. But Kwoyelos was not one of those people who was charged by ICC. So, but in terms of evidence, you see there's a tendency where every wrong thing Connie did is being lumped on these commanders. So for instance here, everything wrong Connie did has been lumped on Kwoyelo. So it's important for us to get the world to know his side of the story. And the decision will be for the judges. Yes. The difference is that you see all of them are international courts, but ours is within the division of the High Court. That's the difference.
Talking to the Deputy Chief Registrar, International War Crimes Division Court, Juliet Atang highlighted the next step after the preparations, including meeting the defense witnesses.
Well, we as a division set up a meeting on 8th of this month, and the essence of the meeting is a precursor to the ruling that was made by the honorable judges on the 18th of December. You realize that on that date, the accused person was put to defense on at least 78 counts. So the essence of the meeting was primarily to ensure that the defense counsels are facilitated to enable them to ably represent their client. So why he's here today is that in that meeting we agreed that Kwoyelo be brought today to court to enable the counsels to freely interact with him in a private space where it would be comfortable to talk to them. And we're looking at projections of possible witnesses. He would be the best person as the accused person to know who his witnesses are before we go to the field, because next week we plan to go into the field to do an outreach with the primary objective of enabling again defense counsels to access their witnesses. Yeah. So we can't go to Gulu because really it's more of a private meeting, but the division is under obligation to ensure that we facilitate the defense. Yeah. Well, that depends on quite a number of factors. And primarily what we are doing now is to prepare. You can't start a defense case without preparing. So we're in the preparatory stages. And from next week, we expect to be in Gulu by 19th. We'll have outreaches within the regions of Lamogi, Pabo, and Gulu Town Council, and also Pagak. These are the places where most of the atrocities and most of the prosecution cases arose from. So once we are there, the defense will be able to, as I mentioned earlier, interact with their witnesses. So once they are done that in a private space, which I cannot reveal for security reasons and witness protection, once the defense is done with documentation, they'll go for what we call disclosure. They are under obligation to share with the state what kind of evidence, what nature of evidence they are going to be presenting. And once they're done with that, we plan to have on the 31st of January this month to have a status conference meeting. Now, in that status conference meeting, the expectation is that defense counsels will brief the panel of judges on how ready they are, what we call trial readiness. Now, that is when the judges or the panel shall give a date for defense, which by my projection should be anything between early February. We should be able to start with the defense hearing.
For smooth preparation of the trial, government through the judiciary injected 500 million shillings.
Yes, indeed. The judiciary is very determined to ensure that this case comes to an end, because the victims have been waiting for quite a long time, understandably. So in the last quarter, we were given 500 million shillings for this particular case, and it's still this money that we are actually using. So we used it very well. We were able to make some savings because of proper planning, and it's able to take us. So by the time the money for this quarter comes, we'll be trial ready, and we shouldn't be having any challenges with facilitation if it comes through. The reason why our government has been very deliberate, and especially also the judiciary, in giving attention to this case, first of all, because the crimes, the nature of the crimes, they are international, okay? They go beyond customary international law, in the sense that the atrocities or the alleged offenses that were committed are so severe because they affect human rights principles, which any state cannot tolerate. So the government has been very intentional also because it has state responsibility to provide protection and security for its citizens. But also, during the atrocity, there were so many destructions of public facilities, communal facilities like boreholes, like schools, you know. But there are also individuals who suffered personally. For example, if you look at pictures, you'll find people who were maimed, their hands were cut off. There were women who were taken into forced marriages, enslavement, because these are the things we see in the charges. So once proved at the end of the trial, these victims are entitled to compensation. And this is one of the ways of accountability, state accountability. You're already aware we had other forms of accountability, like traditional justice mechanisms, where we had matoput. Then we also had amnesty, where some rebels applied, they were vetted and they qualified, and they're back within the community. They've been reintegrated. There's trust telling. But also for those who are adamant or who did not opt for those other options, and the state still believed they had committed crimes, this is another form of accountability. because the people of Uganda need to know that they are safe and that the legal system, the judiciary, and the government has capacity to protect them and provide protection for security. And of course, naturally, when a country is secure, that is when you also see development and investments coming in. But once there's no state of security, then you don't have that.
The justices that are expected to handle the matter include Justice Mike Erubu, Stephen Mobiru, Justice Duncan Gaswaga, and Justice Andrew Byabasaija.
Last quarter, you see, we had already the prima facie case on 18th. We're already prepping the defense team. By the end of this month, you'll have a date for hearing. And the strategy this time round is that the judges of the panel are committed to commit at least 6 weeks of their time with the permission of the Honorable, the principal judge. Once they have the 6, because 6 weeks, we should have a marathon hearing. But a lot also depends on how many witnesses that the defense are bringing on board. Right now, from the communication they sent to court, they are looking at 50. But that's just a projection. I'm very certain that once they go into detailed discovery and conversations with this, they might find that they don't need all of them. Then they'll zero down on their key witnesses. So most of the factors depend on the availability of course, the court, because most of the judges who are on the panel, if you realize Justice Elubu, Justice Mobiru, Justice Gaswaga, in their own right, they are heads of their divisions, meaning they also have domestic obligations. So that's why planning is very important, and that's why the division strategy this time is to do more preparation. So by the time we bring on board the judges, we are ready to hit the ground running. Yes, indeed. The judiciary is very determined to ensure that this case comes to an end, because the victims have been waiting for quite a long time, understandably. So in the last quarter, we were given 500 million shillings for this particular case. And it's still this money that we are actually using. So we used it very well. We were able to make some savings because of proper planning, and it's able to take us. So by the time the money for this quarter comes, we'll be trial ready, and we shouldn't be having any challenges with facilitation if it comes through. It's criminal law. In criminal law, we try you in persona. If you're responsible for an offense, we cannot charge you as a group. So the specific charges that Kwoyelo has been charged with are specific to his actions. While you're aware that also the ICC, with the referral that came from the government of Uganda, I think it was in 2006, was referred to, Joseph Kony was referred to the ICC. So the ICC, if you've been following the news, have also decided to try Joseph Kony in absentia. So you cannot have a system where the ICC itself is trying and then also the nation of Uganda is trying, because trial has already essentially begun at the ICC. So we can no longer now retract him and bring him here. Is providing the state brief witnesses for him. It is an obligation of this court to ensure that the accused person is given the best possible opportunity to defend himself and to be legally represented. It's actually envisaged from our constitution. So we have provided him, but an accused person also can bring a lawyer of his choosing on what we call private brief. But once you do that, then the obligation to pay falls on the accused person. We also don't mind the accused person saying, okay, I'll have a bit of the state brief and I'll also have private brief. But what is important and paramount, the test is that the government must provide. But not just providing, we also ensure that we provide the best to match, because we know the DPP presents its best in high-profile cases like this. So we also have to match the defense case, the defense by presenting the best that is available. So in this particular case, yes, the government of Uganda is providing and paying for state brief.
Prosecution presented 56 witnesses to which court based on in finding Kwoyelo with a case to answer. Thomas Kwoyelo has so far spent 15 years on remand.